Good morning, good afternoon, or good evening. This is my presentation for our ethics conceptual paper for Dr. Rayfeld's class. And the topic I'm going to be speaking on is prioritizing the right to habilitation over the right to personal liberties. The right to habilitation and the right to personal liberties. Ideally, service providers and caretakers should strive toward honoring both of these rights. Habilitation is the teaching of skills for the purpose of fostering an individual's independence. The right to personal liberties has been described as the right to be free from restraint, to be let alone, to plan one's own affairs, freedom to walk or even loaf about, as well as the rights to speech and religion, among others listed in the Constitution. Bannerman and colleagues published a paper in 1990 detailing issues of conflicts between the right to habilitation and the right to personal freedom. Some of these issues include clients' lack of input in selecting treatment goals, disregarding client preferences, not teaching choice-making skills, and limiting opportunities to make choices in favor of goals and treatments that favor habilitation over personal freedom. Though there are conflicts between the right to habilitation and the right to personal freedoms, I do not believe the two rights are mutually exclusive. For this, I'll give a personal example that informs my opinion as to why I believe this. I currently work at a day center for adults with disabilities, and one of the clients that I work with, I believe, is a case where habilitation, the right to habilitation, would not limit his personal liberties, but open up and give access to future liberties that he cannot access currently. I'll give you some background on this client. He is a middle-aged man with severe autism and no vocal skills. He can sign one word, food. And previously he lived with his parents and they were very permissive and they let him eat large amounts of soda, pizza, junk food, whatever he wanted, and if he was denied access to food he would engage in violent outbursts, punching walls, throwing furniture, and the like. And in this situation, before he moved to the residential program, he had, access to exercise his personal liberties, to eat as much as he wanted, and to throw violent fits when he couldn't access food, but he didn't have any other skills. And when he moved to the residential program, the staff decided to put him on a strict caloric diet. And he was able to not only reduce his weight by 80 pounds, but he also was able to alleviate some of his health complications that came from his incredibly unhealthy eating habits, such as his high blood pressure and diabetes. This may be an extreme case, but in this particular instance, I feel that the right to habilitation greatly improved the quality of life for this particular client, whereas the rights to his personal liberties would not have helped him to better his life in any way. So in this case, and in most cases, I believe the right to habilitation is marginally more important than the right to personal liberties. All right, very briefly, we'll go over a couple very important court cases that influence and kind of inform the current state of where the right to habilitation kind of came from and how it's affected in our everyday working lives. So the first is Wyatt versus Stickney in 1971. According to the Harvard Law Review, this is when the right to habilitation was officially established. And according to Perlin in 2011, this court case inspired dozens of copycat cases and kind of set a national precedent towards the right to treatment, to the right to the least intrusive treatment, and as also the right to refuse treatment. this really gave people with disabilities an important right to not just sit in an institution all day, but to really access and be given treatments that will improve their lives, and that it is essentially a constitutional right for them. Another very important court case that helped further and expand the definition to what the right to habilitation was Olmsted versus LC in 1999. This case was two women who were diagnosed with intellectual disability and personality disorder and schizophrenia. They sued the Commissioner of Health Services of the state of Georgia, I believe, because they were denied access to community living, even though they were given the recommendation to live in the community. And for years, they were denied access to the community. So for this reason, they successfully sued the state, and it furthered concurrent deinstitutionalization efforts, but it also set community living as one of the rights to habilitation, that it's an important component necessary and very important for people to habilitate and to develop the skills to live independently and to support themselves. So in researching this topic, I found a lot of articles that kind of looked into the rights of personal liberties instead of habilitation. And I think it's because that topic is a lot more interesting. It's really fascinating to see, what kind of rights that adults with disabilities are denied on a day-to-day basis, and in what kind of ways they're restricted overall. So, for example, I found some articles that talked about how they're limited in their right to have sex, and it's a human right. It's not something you should be able to deny to someone. But however, there are a lot of restrictions, kind of societal and from parents and even from service providers that kind of limit that activity and kind of imposes on their right to exercise their personal freedom. And there are also a few articles about the right to eat. There's one article in particular about one individual who refused to eat, and even though it was unhealthy, it was also his right to deny food, and that force feeding would have violated his personal freedom. However, so it was one of those cases where you had to balance, what is right, what is healthy for the client, but also in a way that, that would respect the client. There was one article in particular that I really liked where I feel like it blended both the right to habilitation and the right to personal freedom, and that was the staff support strategies to increase the involvement of individuals with disabilities in meal preparation. So essentially the clients and the staff were paired up, and they were trained by the experimenters to increase their participation, and also for the staff to support the participation of the clients in creating the meals. And the thing I liked about this study was that not only did it promote habilitation and teaching skills for the client, but it also was opening up and giving them a future skill that they could exercise in the future, that they would be free to do. They would have the choice to make their own meal. They wouldn't have to depend on their staff to do it for them. So I understand this topic is fairly divisive, and I can see why. Both of these rights are very important, and choosing between one or the other I feel is a really difficult thing to do. And I only believe that habilitation is marginally more important than personal liberties. And the good thing we have ethics, because ethics of behavior analysis supports the right to both right to personal liberties and the right to habilitation. And we have guidelines set up to support the pursuit of both of these rights. And ideally, we and other service providers should find a way to encourage both and not have to choose between one or the other. Because ultimately, both are meant to improve the quality of life for the client. And even though most research does focus on choice and personal freedoms, I feel that many freedoms can't be accessed unless you have skills, especially for lower functioning clients. I don't know about for higher functioning, but in my experience, for lower functioning people, learning skills is something you need before you can exercise your freedom. And yes, thank you very much.